defendant's actions that he is entitled to bond, but I just stress that to show the seriousness of this case. So again, just asking that the court consider revoking, and then obviously if the court is not going to revoke, we absolutely would like an increase in the amount of bond based on the information that was in the brief that was prepared, and then the conditions that would allow us to render public especially the victims and their families.
I'm sorry, you were breaking up.
Yeah, you broke up, Ms. Moeggenberg.
Okay. So again, Your Honor, if the court's not willing to revoke the bond, then we certainly would ask for conditions that would allow some protections for the public, and particularly the 11 victims and their family. Thank you.
Well, let's say one thing, she's asked.
Hang on, sir, you better not say anything, because it could be used against you. I know what you say, so I am going to mute you for just a bit here. So I understand the request to revoke Ms. Moeggenberg, but I don't believe I can do so under 6106B, which allows a person to be remanded without bond when charged with murder, treason, or violent felony, which this is. The court rule requires 2 prior violent felonies convictions within the last 15 years, and Mr. Gille does not have any felony convictions that I'm aware of.
Sorry.
And armed robbery, there could be a remand without bond for that charge. Kidnapping, and let's see, and criminal sexual conduct in the first degree. So I don't see that I can revoke, or remand without bond.
And Your Honor, the revocation request was based on the defendant's actions on the day of the, because it would be a violation. I mean, obviously he's not released, but he was told no threatening, intimidating, harassing behavior, and then he immediately made this gun gesture toward the cameras, toward the people involved in the arraignment. So that's what the revocation was based on.
Okay, thank you. So which defense attorney would like to speak to Mr. Gille?
Yeah, right. I believe, I guess first I make a couple overriding comments. I think Ms. Nisley is actually going to handle the motion. I understand obviously the urgency, which is court need to act on the motion. But just for Mr. Gille's sake, as well as mine, Ms. Nisley's, we were just assigned less than 24 hours ago, so we really hadn't had an opportunity to discuss the case level of the motion with Mr. Gille. We did have a couple moments to introduce ourselves yesterday. Ms. Nisley will be handling the motion because she handled the arraignment, and so she at least has some rapport with him. And obviously she can make representations about his mental status and make any requests in that regard. And so those would be, I guess, the first overriding concerns regarding the bond. Also, I wasn't at the arraignment, so I can't speak to the allegations. I do have the motion, but I can't speak to obviously the behaviors or what happened therein or the timing. And so I'd be happy to answer any additional questions, but I think Ms. Nisley is going to handle the motion today in that regard.
All right, thank you, Mr. Graff. So I'm cognizant of the fact that the 2 attorneys were just appointed late yesterday and that this is short notice. It is an emergency bond in a case involving very serious accusations, so I felt it needed to be dealt with immediately. However, you and Ms. Nisley can file another motion on behalf of Mr. Gille, of course, at any time, okay? That's fine. And of course, you can talk to the prosecutor about the possibility of a stipulation, but this won't foreclose the defense from filing a motion again to address bond. So with that, Ms. Nisley, then, any comments you'd like to make?
Yes, thank you, Your Honor. So we certainly recognize that there are many victims here. This has been a tragic situation. We also recognize that Mr. Gille is one of the victims. He's been a victim since he was 15 years of age of the lack of protection and services from our mental health system in this state. We do not believe there's been certainly any bond violation. I was present at the arraignment the other day. I did have an opportunity to speak with Mr. Gille for perhaps 10 or 15 minutes. During that arraignment, Mr. Gille did make some statements that, in my view, were nonsensical. The allegations in this case that somehow he violated a condition of bond by making some sort of hand gesture, I can't, as an officer of this court, I cannot say that that is what I saw. And I certainly don't think that's anything any of our local reporters who have been referring to it as, I believe, a gun finger or some such thing. That is a conclusion drawn by people unaware, uninformed, who have never met Mr. Gille, and they have no idea what he was intending to convey. And simply put, there was no bond in place until that arraignment was completed and that bond was ordered. But there was no bond violation. As Your Honor already noted, MCS 6.106 does not allow for no bond in this case. This is not one of the named offenses. Whether or not, bond could have been completely denied had anyone died, frankly, is a moot point. That's not what we're dealing with here, thank the good Lord. But the court rules simply do not allow for it. Furthermore, I have had an opportunity, as Mr. Graff, today to separately speak to a few different family members who were on the phone to us right away, and I can assure you that based upon their statements to me anyway, they have no intention of posting any kind of bond, nor do they have the resources to post anything near what the bond is currently set. $100,000 cash or surety for Mr. Gille and the resources and the family he comes from is impossible. While we certainly all are aware, I believe, that there's been a lot of social media chatter, again, all of that is irrelevant. It has nothing to do with it. But nobody is going to be walking forward with $100,000 to get Mr. Gille out of jail. And frankly, given his mental condition, where he is now and will remain to the foreseeable future, to then increase the bond, I think it's absolutely demoralizing. He has a very long road ahead of him. There's no need to raise it. In my opinion, there's no justification for it. I suspect that he will be in a county jail for a number of weeks, if not months, awaiting a competency evaluation, which I am asking the court to order today, both the competency and criminal responsibility. The sooner we get that ordered and we get the ball rolling, as we all know, that can take a lot of time. I think it's important for everybody, not just Mr. Gille, but frankly, his family and the victims in this case, to get to the heart of the matter here. And so we would make that request. Thank you.
All right, thank you, Ms. Nisbely. So, Ms. Moeggenberg, whenever the issue of competency is raised, the court is required to grant that request. So would your office prepare an order for competency and criminal responsibility?
Absolutely, yes.
Very good. So do you have any other comments, Ms. Moeggenberg, with respect to, in terms of rebuttal?
Your Honor, just briefly, I understand that the defendant or the defendant's family don't have the resources to bond him out. I spoke with a couple of members of the family as well and understand that they do not intend to get him out. The concern is, again, that this has garnered a great deal of attention. There are many people who are sympathetic to Mr. Gille, as we all should be, because of the mental health challenges that he is facing. But the concern is, Ms. Nisbely says that no one's walking forward with 100,000. We don't know that. And frankly, that amount and that possibility is scary for some of the victims in this case who have been following what's going on. So we are asking for a substantial increase in the bond amount. Thank you.
Okay, last question. You requested specific conditions, I believe. And
Yes, Your Honor.
What are those?
Your Honor, we would ask for a GPS tether if he is released, as well as there was not a no contact listed with the named victims. I don't want to list all of them here I mean, I can, but they're all obviously listed in the complaint. So with all 11 victims and with any family members of those victims.
All right, thank you.
Both those conditions seem entirely appropriate.
So, bond can be reviewed, at any time, basically. So what the court is required to consider in terms of setting a bond, and in this case, a personal recognizance bond is obviously not appropriate under the circumstances. And in fact, the praxis risk scoring form recommends overriding the praxis score due to the severity of the offense. The fact that Mr. Gille does not have any connections to this area, that he's without a home, employment at this time, not from the area, just no connections to the area, and a fairly serious criminal record, which includes 2004, there was a charge in the 90th District Court of, this was a charge, it was dismissed, but it was a charge of felony assault with dangerous weapon. I think the court, for bond setting purposes, can consider that. 2005, in the 90th District Court, there's a conviction for domestic violence. 2006, a controlled substance conviction in the 90th District Court. Another 2006 conviction for assault, misdemeanor assault and battery and retail fraud. There was a felony controlled substance charge that was dismissed as part of that complaint. 2008, felony domestic violence was dismissed, was charged but dismissed. And Mr. Gille pled guilty to aggravated domestic violence. 2012, aggravated assault was dismissed in the 86th District Court. He pled guilty to assault and battery. 2015, charged with disorderly person drunk, however, that was dismissed. 2016, in the 90th District Court, disinterment and mutilation of bodies and malicious destruction of tombs and other memorials between $1,000 and $20,000. The lien indicates that was about those cases were bound over to the circuit court and don't have any verifiable information as to how they were ultimately disposed of. So the court has to consider the following under 6106F. Prior record, well, the prior record is assaultive. There's history of substance abuse addiction. There's evidence that controlled substances were part of Mr. Gille's past. Defendant's mental health, competency exam and criminal responsibility exam have just been requested. So, and I think there's merit for those requests. Seriousness of offenses charged. These are all, if convicted, they carry any term of years up to life in prison. And they're very, very serious assaultive charges with very, very serious injuries to all of the victims. So, of course, we'll consider the charges and the injuries. Employment status, Mr. Gille is not employed. Responsible members of the community would vouch for him. I haven't seen any evidence that there are such folks available and then ties to the community. He doesn't have ties. The last factor is the risk of non-appearance if he was out on bond, appearance for the court proceedings. Well, he doesn't have ties to the area. There's a mental health order of County, I believe it was. And he has no defined place to stay. So there's a real risk in my mind that if he's out on bond, he would not appear. So given all of those bond can be reviewed going forward again, but I'm gonna set bond at this early juncture at $1 million. I think that cash surety, I think that will assure the victims and the public in general that it's unlikely Mr. Gille is going to get out and threaten other people. And I think the victims need to be assured that he's not going to get out of jail. And the public needs to be assured too that he's not going to be in the community and putting them in fear of another such event that happened last Saturday at Walmart. So that's the bond. I'm going to add a condition. This will be with all the same terms and conditions of the original bond. However, I'm going to order a GPS device if he was to bond out. I'm also going to order there be no contact with any of the named victims nor their families. So I think that does it in terms of bond and conditions, but is there anything else from the attorney? Ms. Moeggenberg, start with you.
No, Your Honor, thank you.
All right, Ms. Nisserly?
And do you believe we'll receive the order, the proposed orders this week, Ms. Moeggenberg?
Yes, absolutely.
Great, thank you.
All right, so we're all set, everybody. So obviously the competency request, that will put the file in what proposed CCY says, which is on hold while competency is being done. So the prelim on, I think it's scheduled for the 16th, that won't occur because we have to get the forensic matters completed. So, all right?
Thank you.
Thank you, Your Honor.
Thanks,
Thank you.
guys. Thank you.
Control 764.